Can you imagine what it takes to write a book like Fatal Vision? A book like this doesn't spring full-blown from an author's mind. It takes years of effort, pain, lonely work. A book starts with a blank page. This is how you start a book. It's easy to set someone up in business as a writer. Give them a piece of paper and a pen. It doesn't take much capital. But this is the end product. A sculptor looks at a block of marble and sees a statue. A painter looks at a blank canvas and in his mind's eye sees a beautiful piece of art. A writer looks at a blank page and can visualize the final product, a book of this kind. You heard Joe Wambaugh say a book is a living thing, bigger than the subject and the author. If it's a good book, and this is a good book, it outlives both. This trial is about the attempted murder of this book. You shouldn't let a convicted murderer try to kill another living thing. You can stop this harassment. 8 years ago, the jury in the murder trial thought they'd done the job. Now it falls to you to put an end to this harassment. All our lives the last 6 weeks have been disrupted. Joe McGinniss has been out here, away from his work and family. You've been taken from what you ordinarily do, and the court's time has been taken up for 6 weeks. All because of a spiteful, malicious, vengeful, convicted murderer who didn't like a book that told the truth about his murder conviction. Now think about what's really going on. If a convicted murderer can sue an author who writes a book saying the jury was correct in convicting him, then who is free from being sued for what they write? A convicted triple murderer is the most extreme plaintiff possible in a case like this. For this convicted murderer, these 6 weeks have been a summer vacation. When this case is over, he goes back to prison. It hasn't been a vacation for Joe McGinniss. He's been defending his integrity as a writer and as a man, and defending the integrity of his work, the book Fatal Vision. You remember when this convicted murderer was on the stand? He said he spoke to Sterling Lord in July 1979 to find out what kind of man Joe McGinniss was. The murderer wanted an author who would withstand pressure, who wouldn't submit to pressure, and that's what he got. In fact, he got more than he wanted. The writer he signed on with wouldn't submit to the subject's pressure. McGinniss stood up to him, and he's fighting this case as part of that effort to resist pressure for himself and every other writer now and in the future who might be in a similar position. Remember, there was testimony about what the convicted murderer meant when he said, "Joe will pay." From context, it was obviously a vengeful comment. But on the stand, the murderer said, "Oh, I just meant royalties. That's what I was talking about." Keep that in context. This entire 6-week scenario has been about satisfying his lust for vengeance. Joe will pay. And that's exactly what he has tried to make Joe do, and has made him do for the last 6 weeks of trial and the last 3 years of this litigation. But it wasn't Joe who convicted this murderer. It wasn't Joe who sentenced him to 3 consecutive life terms, the harshest sentence possible. It wasn't Joe who affirmed the conviction. But the murderer can't sue the jury or the courts or the Supreme Court, so he lashes out at the author of the book. The murderer couldn't get a new trial. That was denied, and that denial was affirmed. This trial was the closest thing he could get to a new trial. And you know what? Evidence came out in this trial that wasn't brought out at the original criminal trial. Evidence you heard that had been covered up for almost 20 years. It shows more than almost anything in the book that what Joe concluded in the book is amply supported by additional evidence, and you saw it unfold here in the courtroom. What exactly are you supposed to decide? What have we been doing here for 6 weeks? This is an ugly business. It's about a murderer who wants more money for having killed his family. For 4.5 weeks, we heard the plaintiff's case. We put on our case in about 3.5 days. You remember when Dr. Sadoff was on the stand? He used the metaphor of a sledgehammer and a nail file. He said the government's evidence, the physical evidence at the criminal trial, was like a sledgehammer compared to Dr. Sadoff's nail file. Well, you heard 4.5 weeks of the plaintiff's nail file against 3.5 days of our sledgehammer. We were able to put MacDonald on the stand and, through cross-examination, Hold a mirror up to him. Let him see the countless lies of his life. The mask disappeared. Joe McGinniss was called by the plaintiff and was up there for 3.5 days under relentless questioning. You had the chance to see both men on the stand, to examine how they reacted, to study their behavior, to see who was forthright, who was evasive, who had something to hide, and who is the real con man. You observed both men on the stand. Even on their rebuttal case, we were able to take their expert, Dr. Elliott, and turn him around into our expert, who supported just about every point we were trying to show regarding the customs and standards in the industry, how writers go about their work. We were able to show that Dr. Sadoff, the psychiatrist, admitted honestly that he didn't have the information to make certain diagnoses. That's why, with their case, we proved a lot of our case. In the few days of our own case, we compressed the testimony, had people get up there, give their testimony, and face cross-examination. Mr. McGinniss was on the stand 3 separate times. No other witness was called 3 times. He was called twice by the plaintiff and once by us. And you studied him. It's helpful to consider what this case is not about. It's not a retrial of the criminal case. It's not our burden to prove this man is guilty of murdering his wife and children. That's been done. He was convicted beyond a reasonable doubt, a much higher standard than in a civil case, and that's not the issue here. That's a given. You must take that for granted. There's no presumption of innocence. He isn't innocent. That's the law of the land. So when he maintains his innocence here, it's nothing new. Prisons are full of people who say they're innocent. We also don't have to prove every single statement in the book is absolutely true beyond a reasonable doubt. It's their burden to show that statements are false. And you heard McGinniss testify about the reasonable methods of investigation, the sources he relied on, and you also heard the often trivial and silly examples used by the other side. Another issue we don't have to decide is whether the convicted murderer is insane. That's not for us. We don't have to decide whether he actually abused amphetamines on that fateful night. We don't have to prove he did. And this is not a libel case, as their counsel concedes. So the real issues for you are something else. He has the burden of proof on the allegations he makes. Something that is truly before you are counterclaims by Joe McGinniss against the convicted murderer. Those counterclaims need to be decided. As I mentioned in my opening statement a month and a half ago, it doesn't matter who goes to the courthouse first. You have to weigh the quality of the claims on each side. It doesn't matter if someone is called the plaintiff, defendant, counterclaimant, whatever. The essence of Joe's counterclaims is breach of contract, and the contract is the relationship between these two people. The evidence showed multiple breaches of that relationship. The first, most obvious and significant breach is that he sued at all. Recall that there were 2 exhibits, releases, Exhibits 5 and 6, in which MacDonald freely said he would not sue Joe. Let's look at those for a moment so you can see the language. The first release was August 3rd, 1979, Exhibit 5. Look at the last 2 paragraphs. The next to last one talks about a suit for defamation. This is not a defamation suit. And it has some handwritten language about provided you maintain the essential integrity of my life. But this isn't a defamation suit. That paragraph, as the evidence and testimony showed, does not apply to this case. It's the next paragraph that matters. It talks about libel, violation of right of privacy or anything, and that covers this case. It's anything else, and that has an explicit release. It says Joe is released from any claims by reason of anything contained in the book. That's what this case is about. If the book didn't conclude this fellow was guilty, we wouldn't be here today. The second release, Exhibit 6, December 1981, also covers the book. In the third line of paragraph 1, it talks about books. It goes on to the next page, where at the top it says, MacDonald releases McGinniss from any lawsuits. Libel, defamation, violation of right of privacy, or infringement of any literary or other property right or otherwise. This case falls into the or otherwise. What other language could people use to be so clear? These were the broadest possible releases in both instances. You heard testimony on what releases are for in the publishing world, to protect the author and publisher against harassing litigation. That's why they have those releases. Now, counsel didn't show you those releases yesterday. Those releases are one of the keys in your decision-making because, as the court will instruct you, if you find the releases apply and are valid, they're a complete defense to the fraud claim, the emotional distress claim, and the breach of the covenant of good faith and fair dealing. Keep that in mind. But our counterclaim is based on the lawsuit. The lawsuit violated those two documents. Clear, unambiguous, with no two ways about it. But that's not all. Recall the original contract, Exhibit 2, I believe. It talks about exclusive story rights that MacDonald was giving to McGinniss. Exclusive rights. The evidence showed a breach of that exclusivity. A massive wholesale breach. We have Melinda Stevens's book, I Accuse, which was put into evidence. On cross-examination, the convicted murderer admitted his participation in editing, reviewing the manuscript, cooperating with the author, giving information. He was breaching the exclusive obligation he had to McGinniss. Then we saw their own witness, Dr. Elliott. He's writing another book about MacDonald, and MacDonald is cooperating with him. MacDonald even said he's helping with one or two other books. Certainly that testimony alone shows cooperation that breached exclusivity. They try to question how long the exclusivity was supposed to last. Let's put that to rest once and for all. Look at Exhibit 6, the second release, again on the second page. If you look at the last paragraph, paragraph 4, in that release, which is about book rights as well as anything else, it says, without limiting the foregoing, I agree that all of the consents and rights herein granted, which includes the right to do the book, to you shall be exclusive and perpetual. Now even the convicted murderer, after some hemming and hawing, had to admit perpetual has only one meaning, forever. So again in black and white, we have the length of the exclusivity spelled out, confirmed by both parties clearly. Now you may ask, if the words are so clear, what are we doing here? Something said yesterday explains it. The convicted murderer, through his lawyer, said one sentence that expresses their attitude toward legal and other documents. He said, I don't care what the words say. Do you remember that? I don't care what the words say. Well, we care. McGinniss cares. He lives by wielding the written word, and you should care. In addition to the breach of the covenant not to sue and the breach of the exclusivity requirement, there was a further breach, the breach of his agreement to cooperate. On the stand, MacDonald talked at length about how fully he cooperated, nothing he wouldn't do for McGinniss. He said he instructed investigators, lawyers, his family to give everything McGinniss asked for, except one thing. He refused to authorize Cleve Baxter to speak to McGinniss. Now we know why. For 17.5 years, until Tuesday of this week, the convicted murderer covered up his failing of the polygraph examination on April 23, 1970, and he was successful until Tuesday, 2 days ago, in that cover-up. That's why he didn't let McGinniss speak to Baxter. That was a breach by MacDonald of the agreement to provide exclusive story rights, which include cooperation. Yesterday, you heard some attack on Cleve Baxter's credibility. Cleve Baxter has no bias or motive. He said he never read Fatal Vision, and he honored the confidentiality of his client for 17.5 years. It was only when called as a witness in a court of law that he revealed what really happened. To suggest, as counsel did, that somehow we were obligated to ask Bernie Siegel, MacDonald's lawyer, about it, since Siegel was the only other person there, is looking through the wrong end of the telescope. Bernie Siegel was the murderer's lawyer. He could have been called on rebuttal. They could have brought him in. He lives in California. If Siegel had a different story to tell, he could have taken the stand. But he's one of the missing witnesses in this case. Don't you think that if Siegel could have corroborated their version, they'd have called him? But Siegel couldn't take the stand and disagree with Cleve Baxter. because he knew Baxter was telling the absolute truth. This is just one example where you'll have to decide whether to take the word of this convicted murderer or the words of several other people with no axe to grind. To believe this convicted murderer, you'd have to disbelieve a host of other people who have no reason to lie, while this man has every reason in the world. That's not the end of this man's breaches involved in our counterclaim. From the very start of his relationship with McGinniss, he lied. He lied about his supposed innocence in the crimes, and he lied afterwards in supplying information. He committed a fraud on McGinniss. He also tried to stop the publicity surrounding the book. He testified about letters he wrote to talk show hosts and TV programs to try to stop Fatal Vision publicity. He was subverting the whole purpose of the contract. The court will instruct you later today. Part of doing business together is the requirement that people honor their obligations in good faith. The convicted murderer didn't do that. He, not McGinniss, breached the covenant of good faith and fair dealing from start to finish of the relationship. In law, we sometimes speak of the doctrine of unclean hands. This man comes to court with blood-soaked hands. The murders may be 17 years old, but they aren't an abstraction. Don't treat them as abstract. They were real people, and there are living victims. You heard one the other day, Fred Kassab. He's a living victim, a link to what happened then. One of MacDonald's claims is for emotional distress. Just think about Fred Kassab's emotional distress, and you'll see what this case is really about. It reminds me of the famous lines from Macbeth. You know the title Fatal Vision comes from Macbeth. Lady Macbeth, with blood on her hands, says, "Out, damn spot, out!" But the blood won't go away from this murderer's hands. This isn't idle chatter, it's real. What do we seek as damages on the counterclaims? McGinniss says that what MacDonald did, the multiple breaches, the lawsuit, the breach of exclusivity with competing books on shelves while Fatal Vision was still being sold, completely undercuts the contract's value. The lying from start to finish, the breach of the covenant of good faith and fair dealing, mean you should award damages of the $90,000 this murderer has already received, plus roughly $100,000 in escrow. In other words, McGinniss is asking you, on the breach of contract counterclaim, in all its parts, to award $190,000 in damages, though you can decide what's appropriate. It's up to you to decide maybe it's worth more than $190,000 to adequately compensate for what happened here, which was a complete destruction of a good faith relationship. Aside from the counterclaims, perhaps the main issue is a very interesting one. Whether Joe McGinniss had the right, under all the circumstances, to conclude in his book that a convicted murderer was, in fact, a convicted murderer. Whether he had the right to conclude in the book that MacDonald was guilty, as the jury determined unanimously in only 6.5 hours. You heard expert testimony from a number of writers. Every one of them said an author's duty is to the truth, that under all circumstances, no matter what, an author should not write something in his published work that he doesn't believe. So that's our starting point. If McGinniss believed and concluded that MacDonald was properly convicted and guilty, then he had to write that. Now, the convicted murderer starts from a different premise. He wanted McGinniss to perpetrate a fraud on everyone else. He wanted the writer to conclude he was innocent. Even their own witness, Dr. Elliott, said it would be unethical for a writer to proclaim someone innocent when he felt they were guilty. Yet that's what this case is about when you strip away all the layers, when you get to its heart. That's why we're here. This was not an as-told-to book. You've seen Iacocca or other celebrity books where both names are on the cover and the celebrity signs the contract. That's not what we're talking about. This wasn't a collaboration. This was an arm's-length transaction between two people, a subject and a writer. Remember, we introduced a letter from Joseph Wambaugh from 1975 when someone, on the murderer's behalf, approached Wambaugh about a book. Wambaugh wrote back describing the kind of book he'd write. So despite counsel's comment yesterday that we can dismiss Wambaugh as not serious, the fact is they went to Wambaugh first. And Wambaugh said exactly what McGinniss said. I have to have complete freedom. I'll need releases. and you have to face the ugly possibility I might conclude you're guilty. As Wambaugh said in that letter, Exhibit 163, very clearly, it's exactly what happened in the McGinniss relationship. You heard Mr. Buckley, Mr. Wambaugh, and Mr. Elliott all say that the writer has complete discretion, that it's his obligation to write the truth as he sees it. That's the basic right of any writer. It's what it means to be a writer, unless you're a kept journalist, which we don't have here and which Joe McGinniss is not. We want independent writers. Now, specifically about the relationship between McGinniss and MacDonald, let's highlight the specifics. In June of 1979, not May, as on a timeline shown in court, but June, the parties met for the first time. That meeting concerned a newspaper column Joe was writing for the Herald-Examiner. Remember the testimony? MacDonald wanted certain things in the column. Joe wrote it his way, and MacDonald didn't like it. It showed from the start. Joe is the kind of writer who will write what he thinks he should write, and no one, no subject, no editor, no one will tell him what to write if he doesn't think it's appropriate and true because it's his name on the writing and it's his reputation and his life. Then we come to the preliminary conversations. The murderer admitted he brought up the subject of having Joe write the book. They had conversations, and there were two basic conditions Joe insisted on. He said, "Look, I must have complete access and cooperation during and after the trial. I don't know whether you'll be convicted. I need cooperation. And two, I must have complete control and freedom to write what I choose." These were agreed to. No contest about that. What did that mean? It meant Joe would hear versions contrary to what the murderer was saying. He was going to speak to other witnesses, the prosecution people. Now the murderer claims he wanted a book that was true, accurate, and fair. He got it, more than he ever hoped for. The problem is he never thought McGinniss would escape his manipulative control. He never thought anyone could disagree with him. When he talks about true, fair, and accurate, the murderer means what I think is true, fair, and accurate. But we have objective standards and the writer's vision of the truth. And you've all read the book. You can draw your own conclusions. We'll talk about that in a bit. In essence, the murderer was taking a risk. From the outset, his own testimony confirms this. He wasn't insisting, demanding, or even asking for a book that proclaimed his innocence. He didn't know what the book would say, and there were no controls on Joe of any kind. We'll see if that ever changed. But all the discussions and contracts are based on that premise. MacDonald bet and lost, and now he's trying to recoup his loss because he says he didn't understand or didn't like the book's outcome. Now, if we look at the basic agreements themselves, those July documents, Exhibits 2, 3, and 4, we see there was no restriction on what Joe could conclude. He was supposed to have complete freedom and control to conclude what he wanted, to interview who he wanted, absolute discretion. And MacDonald's promised cooperation is implicit in the agreements, which MacDonald admitted on the stand. He never claimed the agreements, though they don't explicitly mention cooperation, meant he didn't have to cooperate. He did cooperate. It was in his financial interest to cooperate. He was a junior partner in McGinniss's writing project. He had every reason to try to make that book a bestseller because he was sharing in some of the proceeds. That's why he was motivated. Now, the fairness claim can be dealt with quickly. In the book, there were about 1.5 pages on the Silverman psychiatric report, which was adverse to the murderer. But there were over 50 pages added late in the writing process about psychiatric testimony that was pro-MacDonald, introduced at the grand jury. So if you're weighing fairness, think about 1.5 pages of adverse psychiatric testimony versus more than 50 pages of helpful, favorable testimony. Contrary to the claims made in court, you now know the book does refer to new evidence after the trial and deals with it. It doesn't conclude that evidence helps MacDonald, but it deals with it fairly. All MacDonald complains about is that the new evidence doesn't support what he thinks it should, even though all the courts have rejected it. There's an entire chapter in the book on the Army's Article 32 investigation, which came out favorably to MacDonald. That's in the book. And if you look at the book's structure and writing, it's organized such that at the beginning we see the crime itself without knowing how the book ends. It's absolutely fair. It's true in every sense of the word, and it's accurate. Perhaps the real complaint the murderer has is that it's too true, too accurate, and too fair. Now ask what happened after July 16, 1979 that changed things. When the contract was signed, McGinniss had total discretion and freedom to draw any conclusions he wanted. At what point after signing did he forfeit that right? When? What piece of paper or conversation changed that contract? The answer: nothing. It never happened. The contract didn't change. The basic element, a writer's right to make his own conclusions, never disappeared. It was only in the murderer's mind. Now, the first thing after the contract, July 16th, was the first release, August 3rd, 1979. Look at that again. We're not talking about the covenant not to sue right now. Look at the second paragraph, last sentence. You may include in the book any incidents, characters, dialogues, actions, scenes, and situations that you desire. That's a letter from MacDonald to McGinniss. He's giving him carte blanche. That perfectly matches the contract, the preliminary understanding, and all subsequent history up until this lawsuit. Combine that with the other paragraphs and you see a pattern explaining that everything was done to further the author's discretion. They don't attack that release's validity. What they say somehow is that a release can only add, not detract, from an author's rights, but that some handwritten language provided that the essential integrity of my life story is maintained, even though it's in a defamation paragraph, somehow created a contractual obligation on McGinniss to do that. We'll show later that this triple murderer has no essential integrity in his life. You saw that in the courtroom, and it doesn't trouble us. But the first hurdle is that language doesn't apply to this case. And even after it was added, recall MacDonald's testimony. He said, "I still don't like it. It still gives Joe the right to write anything he wants. I'm not happy with it." But he went ahead anyway. No one stopped him or his lawyer from suggesting any other changes. Every change they asked for was agreed to. He had counsel, an experienced counsel. He has a Princeton education. He knows what words mean. But again, perhaps this is the application of what his counsel said yesterday. He doesn't care what the words say. It suited his purposes then. Now, for a different purpose, he'll try to rewrite the agreement. The second release came in 1981, generated by Dan Kornstein, the movie man. To do a movie based on a book, a release has to cover the book as well, and this release does. It supplements the first release. It was sent to MacDonald in October 1981. He wasn't in prison then, he was out briefly. He kept it about 6 weeks before signing and returning it. He had 6 weeks to consult any lawyer he wanted. He chose not to. The words are simple. They're words we all use every day. It says books. It talks about Joe's discretion. Twice it says in your sole discretion. It says Joe can, quote, edit, splice, rearrange, even fictionalize. Yes, it even says fictionalize. He can simulate, he can combine. It talks about tape recordings and interviews. Again, plain, simple English. A release from the subject to the author. Now, they claim somehow this was a product of fraud. We'll get into what fraud is, but you heard the evidence and testimony. The words say what they say. They were understandable. He had a month and a half to study them and get counsel. He didn't even suggest a change or ask for a modification. He signed it because he was going to get money from the movie. You remember McGinniss on the stand said that from the beginning he told MacDonald releases were necessary. You can't do this project without releases. Publishers won't take the book without releases. Movie people wouldn't do the movie without releases. It's not a project you do without a release. So from the very start, the release was understood as necessary. And the consideration, when we talk in law about consideration, that's the quid pro quo, what you get for giving something. The consideration for the releases was the entire deal, the share of the proceeds. If the releases didn't happen, there'd have been no proceeds. It was part of the transaction, an integrated transaction. The 4 documents that make up the contract are Exhibits 2, 3, 5, and 6, the basic contract, the consideration form, and the 2 releases. Those 4 documents form the overall contract. The consideration of the proceeds applies to each of them. They can't be read separately. That's not even counting what's said on the face of each release about a small sum of money, $10 in one case, $1 in another, exchanging hands as consideration. As the judge will instruct, any amount of money, no matter how small, is sufficient consideration. And in both cases, MacDonald signed the documents acknowledging such consideration was received. Now, on the stand, as so often happened, the convicted murderer even disagreed with himself, his prior testimony and writings, further showing a lack of credibility. But we have his own signature on the documents, acknowledging the consideration. So we have 2 kinds of consideration. 1, the original proceeds share, and 2, separate consideration for each release. These releases were valid, binding. They did the trick. They were absolutely essential, vital. Without them, there'd have been no book, no movie, and he had a financial interest in seeing those happen. In a case like this, with credibility at issue, you look for evidence that doesn't lie. You look for documents signed by the parties so they can't later say, "I didn't say that." We have documents, releases, that don't lie. And now we have a series of letters between the convicted murderer and the author that demonstrate beyond any doubt that the murderer understood all along, through 1983 and publication, that he had no control over the book's content or Joe's conclusions. In his own words, the first letter is Exhibit 119, October 1980. Significant timing. In early October 1980, Joe had dinner with Bernie Siegel and another person. They talked about the book. Remember the testimony? Joe was asked what he was going to conclude. He said he didn't know. They pressed him, and he said, "Look, I have a moral obligation to the truth. I don't have a moral obligation to MacDonald." Then on Sunday, October 12th, Exhibit 115 comes out, an article in the San Francisco Chronicle. Joe gave an interview about his Alaska book going to extremes. In the last paragraph, the interviewer asked, "How will you conclude? Was MacDonald guilty?" Joe hedges. He says, "Well, the reader will just have to wait and find out." Right after that, 2 days after the article, MacDonald writes this letter to Joe, Exhibit 119. In it, he says, "I just finished a strange conversation with Bernie Siegel." The call between Siegel and MacDonald about Bernie's meeting with Joe, in which Siegel was telling me how he sort of confronted you with some request as to how you view my guilt or innocence. I poo-pooed it with him, thinking he was exaggerating his statements and your lack of response. Reading your quotes gave his version of your meeting a new weight and sobered me significantly. What that means is, as of October 1980, the murderer knew the writer was exercising his discretion, that the writer was not a kept journalist, not in the murderer's hip pocket. He was independent and free-thinking. As early as October 1980. That's inconsistent with someone who thought there was an obligation the book would portray him as innocent. Now let's go to a letter 2 years later. April 14th, 1982, Exhibit 117. Another letter from the murderer to the writer. He says, "There is one thing I really want to discuss with you. I haven't ever asked you for any favors regarding the book, and I don't normally think it's my place. I decided to go ahead on my original agreement based on my feelings, perceptions about you as a person, and not on any right to review material or anything else, including money. As a matter of fact, as you know, Joe Wambaugh offered way more in cash up front." Footnote. You heard Wambaugh on the stand. Another case of someone else telling a different version than MacDonald. Remember Wambaugh saying he never offered any money? The supposed $200,000 or $300,000 was a fabrication, a fantasy, pure fiction. And remember MacDonald insisting it happened. Another credibility question, who do you believe? Joe Wambaugh or a convicted triple murderer. The letter goes on. I never ask you what you are writing or how you feel about anything, i.e., me, Beanie, his mother, evidence, etc. But I want to request one thing of you. Please, please treat Sherry Sislove, his girlfriend, with grace and gentleness. That 1982 letter clearly shows the murderer's thinking. He has no control over the book's outcome. He doesn't know what the conclusion will be. He acknowledges it, but he's making one request, that his girlfriend be treated nicely. That's all he asks. Again, he doesn't know what the writer is going to do. There is no obligation that the writer is going to proclaim the murderer innocent. The next letter in that same month is Exhibit 120, April 27, 1982. In the PS to that letter, in MacDonald's handwriting, he writes, F. Lee Bailey's associate was totally aghast that I had no artistic control over the book. I said, you don't understand Joe. He seemed to feel my naivete hadn't burned out yet. Surprisingly so, he said. I hope, A, I'm not naive, and B, I have no reason to be aghast at my lack of artistic control. That shows he's aware he doesn't have control. But what did he say on the stand that meant to him? He said it meant where you put commas and some adjectives in a phrase. That's what he claimed in 1987 artistic control meant. That's so unbelievable, it's nonsense. It wouldn't have been a PS to a letter if it was just about commas. He knows what artistic control means, what the book's content will be, not where commas go or what adjectives you use. Another pure fantasy, made up to try to defraud you, the jury. Then we have Joe's response to that letter. If any doubt remained, Joe's response, Exhibit 253, May 4th, 1982, laid it to rest in ringing words. He addresses F. Lee Bailey's associate's comment, responding to MacDonald's letter. To be blunt, let the lawyers stick to lawyering and leave the writer to take care of the book. What lawyers know about artistic control is what I know about thoracic surgery. I never would have considered getting involved in this in any capacity if that question had ever been raised in 1979, and Bernie, whatever other foibles he may have, was able to recognize that. Not only I, but any writer of merit or integrity confronted with a situation such as yours would have to insist on complete freedom to write whatever book he finally found emerging from the entire situation. That is what Joe Wambaugh told you in 1975. It was what I told you in 1979. It is what Robert Sherrill, John Sack, or any of the others would have told you in 1979. On the next page, page 5, Joe continues. Your complete cooperation. This is near the beginning of the second full paragraph. And your full granting of all artistic rights are all that persuaded me for the first time in my career to embark upon a project where someone else received income for work I did. And then dropping down, the meaning of the word artistic and the commitment that any writer of quality has to freedom and independence and truth. So you have this exchange of letters. MacDonald writes in a PS about being aghast at lack of artistic control. McGinniss responds with these ringing words. Don't you think that if the murderer's story during this trial was true, he'd have written back to McGinniss the day he got that response and said, Joe, you're out of your mind. We never agreed to that. You're crazy. You promised something else and now you're reneging. That would have been the response if the murderer's story were true. It didn't happen. The documents don't lie. It's not someone getting on the stand conveniently saying, I don't recall. This is the paper trail, the real thing. This is how it happened. But that's not all. There's more. These documents just won't quit. The next is Exhibit 36K, August 6, 1982. It's a letter from McGinniss to MacDonald. If you look at the second paragraph, beginning obviously, you'll see the phrase, this is not an authorized version, hence less believable version of events, and I have been operating with complete freedom and independence. Did the murderer write back and say, Joe, you're off base, that's not so, that's not our deal? Did he? Did you see any letters? Did counsel show you any of these letters? Did MacDonald want you to see them? No. Part of the deception, the effort to fool you. But you won't be fooled because it's his conduct, his words, and the lack of a natural response that's telling. Remember what Dr. Stone said about the tapes. Sometimes you learn more about a person from what isn't included than from what is included. Here, the lack of response tells us more than almost anything else. There's a famous Sherlock Holmes story referencing the dog that didn't bark in the night. Dr. Watson asks, "Why is that significant?" Holmes says, "Because the dog didn't bark." Here, what's significant is that MacDonald didn't respond on multiple occasions when, if the story he's telling now were true, he would have responded. The next letter, same month, Exhibit 131, August 13, 1982. It's a letter from Bernie Siegel, his own lawyer, to MacDonald, essentially saying he's uncertain of Joe's position based on an excerpt he's read. Just doesn't know where Joe's going. Shortly after that, dated August 22, 1982, the murderer writes a letter to Joe, Exhibit 118. In the first paragraph, fourth line down, MacDonald says, "I had made myself a promise not to question you on the book. I've told you, and I mean it, that I had decided to go with you on the book without any controls to protect me, as I could have gotten with a lesser writer, because of my feelings about you as a person. Could he have been any clearer? What words could the murderer have used to acknowledge, before the writer, before you and the world, in August 1982, in response to his lawyer's letter saying, 'I don't know where the author's going,' that 'I can't tell you what to write, it's up to you'? Maybe he's expressing a little nervousness, but it's inconsistent with the story he's telling now. Now, Exhibit 13, we don't have a transparency of. It's a letter dated February 16, 1983 from McGinniss to MacDonald, telling MacDonald he can't have an advance look at the book 6 months before publication. Joe says, "As Joe Wambaugh told you in 1975, with him you would not even see a copy before it was published. Same with me, same with any principled and responsible author." Then he adds, "The book is not part of either your legal or public relations campaigns. My commitment to its integrity is absolute." Is there a response to this letter? Yes. Wait until you see it. Exhibit 158, the next day, February 17, 1983. Look at the sixth line down, beginning, "It is not my right." It reads, "It is not my right, as per our agreement, to tell you what to write or have other power, etc." He was contrasting that with what he claimed was his right to see the manuscript. He says, "It's not my right to tell you what to write." Then there's Exhibit 159, later that month, another letter from the murderer to the writer. He says the same thing again, underlined. "It was one thing not to have control over the book contents you. I granted you that and have lived with it, except I asked you to treat Sherry well and Jay well for very different reasons." How many times does the guy have to say the same thing before it's clear to everyone that he never had control over the book's content? That he never had control over what Joe would conclude from start to finish until he saw the book and didn't like it. And because he has a constituency to please and needs to raise funds for whatever purposes, he has to bring a lawsuit. But there's no basis for it. Letter after letter over the years supports what McGinniss is saying and what the facts show. In the face of this withering, one-sided evidence, no evidence the other way, what is MacDonald's argument? I think he's saying that somehow Joe's comments over time led MacDonald to think Joe was going to write a book portraying him as innocent. On the tapes are a number of MacDonald's statements. One is particularly relevant to what he's claiming. He's speaking in a different context, but it gives you his mindset. In fact, that was never promised to me. I just assumed that it may happen. He wasn't talking about this situation specifically, but it shows his outlook. This is confirmed by something in the book. One of the psychiatrists he planned to call at the criminal trial was Dr. Bailey. At page 372 of Exhibit 402, the book Fatal Vision, Bailey discusses his analysis of MacDonald and explains what he means by a hysterical person. which he suggests may apply to MacDonald. Bailey says, if presented with 20 pieces of data, he is capable of seeing only 3 or 4 and drawing his conclusions from those. I see him as that kind of person. Essentially, Bailey is saying MacDonald has a form of pathological optimism. He won't interpret the facts in front of him. He'll see what he wants to see. That applies to many things, but especially to this business about whether the book would conclude he was innocent or whether there was any obligation. MacDonald also points to letters from Joe between about September 79, right after the conviction, to March 1980. He says they were sympathetic, sensitive, understanding, and they were. They accurately reflected what Joe felt. There's nothing wrong with that. They weren't deceptive. They were the heartfelt response of someone who'd been close to a person who was just convicted. The oral conversations the murderer testified to are very peculiar. Throughout this case, there was never anything in writing saying what the murderer claims. Joe never said in writing, "I'm going to portray you as innocent." So what does the murderer say at trial? He has to make up a story of oral conversations where Joe supposedly said that. Now it's his word against the author's. Credibility conflict. No other witness said that. The murderer's mother didn't say it, though he claimed she was a witness. He said there were other witnesses. Sherry Sislove in California. Don't you think he'd have called her if she'd heard that and could support his version? Another missing witness. Look at the totality. There were no such witnesses because those conversations never happened. They're in the category of the Wambaugh offer of $200,000 to $300,000. They're like his story about killing one of the intruders. Phantasms, hallucinations, a delusion. It didn't happen. He's fabricating it now and did so during the trial. He says he was misled to cooperate by giving the tapes. But he had a pre-existing duty to cooperate, agreed to in advance. There was nothing he was misled into doing. He had hopes. He wanted things a certain way, but that's not something he can pin on someone else. Then he talks about Joe's newspaper interviews in fall 1983, where in 3 out of about 100 interviews, Joe said something like, "I decided I was of the opinion that he was guilty during the trial." Or at the end of the trial. We have to address those. The way to explain this entire thing is to try to unpack Joe's mental processes. As the evidence showed, and as we understand with common sense, on many important issues we approach them not knowing exactly how we feel. We approach with an open mind. We hear more evidence. We do more investigation. And sometimes we go back and forth. We try to understand more. We might have an opinion today on an issue, tomorrow another, as we learn more. That's a common experience for all of us. Here we have a gripping horror story. Imagine what happened. Joe meets this fellow, MacDonald, before the trial. Joe approaches that phase with an open mind. He doesn't know anything. He just hears what MacDonald tells him. He hasn't formed conclusions, certainly not through the trial start. Then Joe attends the trial. He begins that with an open mind. He hears and sees evidence as it comes in, responding to it. Yet he's living in the same house with the defendant, eating with him, running with him, as we heard, dealing with other people, talking to defense lawyers, participating in some sessions as a writer, always with his notebook, because while he developed a personal relationship, the entire purpose of that relationship was to get the book. Now Joe liked this fellow. He liked his personality, was charmed by him. The verdict comes in. He responds as a human being. He's upset. But then we see a conflict developing, head versus heart. He sat through the evidence. He saw the horror of it. But he developed a liking for this person. Surely in our own lives, we've seen situations where people we like or love get into trouble. And we try not to believe they're capable of it because we know them so well. We say, he couldn't do it. I know him. He's not that kind of person. We resist the intellectual pressure of the proof. That's part of what happened here. During the immediate period after the trial and conviction, Joe was going through that process significantly. He'd sat through the evidence, seen the photos, saw what the victims looked like. Be thankful you didn't have to see those pictures. They had a profound impact on his thinking. He had to keep those images in mind, the brutality, and square those horrible images with the man with the nice haircut, white shirt, pinstriped suit and tie. He had to square the crime's terrible nature and evidence with MacDonald's Princeton education. That was a difficult process. He didn't know how he would do that. He had to try to understand how, why, is it possible. During that period, September 1979 to March 1980, he still felt a personal attraction, a liking, even a friendship with MacDonald, the plaintiff in this case, but the murderer. The letters reflect that. Every letter during that period that could even be construed as believing the trial shouldn't have ended as it did is in that immediate period. But what happens? What accelerates the process? The impact of the horrible evidence. And Joe talking to Joe Wambaugh in fall 1979. Remember what Wambaugh said about their conversation. Wambaugh put Joe on the track of the sociopath. Wambaugh told Joe, "It's not a question of good or evil. Those aren't the only two alternatives. It's not a question of this man being worse than Hitler." Remember Wambaugh's words. No, there's a third alternative, one Joe hadn't considered, the sociopath. A man without a conscience, who doesn't have the feelings the rest of us do. He walks, talks, looks like us, but doesn't think, act, or feel like us. Some part inside is missing. That's what Wambaugh explained to Joe. Joe now had something he'd not encountered before and didn't know how to deal with, but it stayed with him and played a role in his later thinking. Joe is changing over time. You recall Dan Wigetow's testimony that by December 1980, Joe was still making the sympathetic case, playing devil's advocate for MacDonald. Wigetow said, "It seemed as if he thought MacDonald was innocent." That's as late as December 80, showing the internal conflict Joe was going through. Even on the October 80 West Coast trip, when he talked to Bernie Siegel and did the Chronicle interview, you see vacillation, not knowing, inconclusiveness. He's forming opinions, reforming them, studying. At some point, testimony indicates after June 1981, Joe became convinced the murderer was guilty, and he thought he had a theory. Now the letters change. You've seen them. What started as one type of correspondence switched to a much less chatty, more formal kind, with no more friendly discussion. In March 1980, McGinniss began interviewing prosecution people, some witnesses, some prosecutors, some jurors. Once he did that, he never again wrote to MacDonald or told MacDonald anything critical of those people after speaking with them. MacDonald knew Joe was going to speak to those people, but the murderer never asked what they told Joe. He didn't want to know. And nothing in the letters after that shows Joe criticizing the prosecution. What is a writer to do in this situation? Isn't he supposed to follow the trail wherever it leads, even if it causes him personal upset? Isn't he supposed to do exactly what he did? You heard testimony from Cynthia Crossan, Linda Healy, and Nancy McGinniss about Joe's attitude. They're people he talked to. Each said that early on he was very sympathetic, seemed to believe in innocence. But that process changed over time and he stopped talking, even to his close friends Crossan and Healy, about his conclusions. He kept them to himself. He didn't want to talk about it. That's the setting before August 1982. Then there's that phone call between MacDonald and McGinniss. We have different versions of that call. The only corroboration is Nancy McGinniss overhearing Joe's side, where Joe says MacDonald wanted to know if he could count on the book for his publicity campaign, and Joe says, "No, I don't think you can count on it for that. The murderer has a different story. You'll have to decide who's lying and who's telling the truth." Then we come to the newspaper interviews when the book was published. Now, the way to handle that is, as testimony and evidence show, McGinniss was oversimplifying a very, very complex process for reporters who would compress it into a line. In doing so, he was saying he was duped or felt duped and conned, trying to show he was really smarter than he was. It was a natural reaction, one we all have. We must see it as such. The newspaper interviews don't accurately reflect precisely what was going on, but even those, and even his deposition, if read carefully, explain what Joe meant. He'd say, "I had an opinion during the trial that he was guilty," but then goes on, "But I was so troubled by it I couldn't square it with everything else I knew. I had to look further." One of the best explanations of Joe's mental process is in the book itself. During deliberations, you may want to look at Exhibit 402, pages 589 to 591. Joe explains in those 3 pages what he was going through and how he went about it, giving the reader, and now you, an idea of what it was like. You heard Joe twice quote an author on the stand to explain what this process involved. When did you come to believe something? When did you know it? He quoted Flannery O'Connor. "I write because I don't know what I think until I read what I write." It's the process of writing that crystallizes thoughts, weighs arguments pro and con. It's a bit like a trial with the adversary process. The writer goes through that internally, sifting wheat from chaff, sometimes taking a long process before knowing exactly where you come out, especially when writing a 700-page book about a difficult problem. But other factors bear on this process. You heard Dr. Samanow talk about the criminal personality. He's written books on it. He explained parts, significantly the manipulative aspect of the criminal mind, the chronic lying, the fact that people are often fooled. Dr. Samanow said he's been fooled as a therapist and counselor. You heard William Buckley testify that he was fooled by a fellow he supported who later committed another horrible crime. Joe was fooled. Fred Kassab was fooled at the beginning in 1970. That's the process, a process of chronic lying, and doctors are not exempt from it. Samanow said ministers, doctors, people in all walks can commit violent crimes. What we're talking about is on the inside, the part you can't see, the part with a mask. In fact, one of the leading books in the field, as testified, is called The Mask of Sanity. The terms psychopath and sociopath explain it. The classic explanation in a sentence of how you determine what you're dealing with is quoted by Joe in Fatal Vision. He says, "Only very slowly and by a complex estimation or judgment based on multitudinous small impressions do you ultimately come to realize what you're dealing with." It's the little things over time, the lies that don't hang true, the way he deals with people, despite the front, the ability to lie without feeling bad, the ability to hurt without guilt. Then we have powerful evidence in how the profession and literary world handle these things. The evidence shows Joe never misrepresented his views. Buckley and Wambaugh testified that the task is to get the story, and you do what's necessary to get it. You lubricate the flow of conversation. You appear sympathetic and understanding. Truth is the goal. You allow the subject to continue believing how you feel about him. That's what you're supposed to do. The mission is writing that book. Remember, Buckley said, "A writer is an artist, and he wants to encourage the subject of which he's making a portrait to reveal himself." That was done here. And a personal relationship that may develop between a writer and subject does not limit the writer's discretion. Sometimes Buckley and Wambaugh both said this. You tell a subject something you may not actually believe to get more information. You encourage the subject to tell you everything. This is particularly true, as Wambaugh pointed out, with a psychopath. You're supposed to allow the psychopath to believe he continues to manipulate you. That's what he needs to feel. That's his reason for being. Of course, we know it's common for subjects of writing to feel betrayed. It happens all the time. I suppose it also happens that people feel friends have been false. But lawsuits aren't based on false friendship or feeling betrayed about something written. In some ways, this case looks like a palimony lawsuit. The friends broke up and one is suing the other, but there's no legal right. False friendship isn't a cause of action. We're talking about much more serious things. And per the experts, Joe didn't even have to be as sincere and honest as he was. but their testimony provides a complete shield for him, and the evidence shows he doesn't even need it. Then there's the question, did Joe have an obligation to disclose his views to MacDonald? That's one of the clearest points. Everyone who testified said no, he had no obligation to say he thought MacDonald was guilty. That would have been silly, ridiculous. You just don't do that. You don't tell your subject that. That's expert testimony, common practice, and common sense. But beyond that, consider specifics here. Why couldn't Joe have told the murderer he concluded he was a murderer, as the jury did? It would have stopped the flow of information, ended the relationship. Even the murderer testified, absolutely, I wouldn't have cooperated anymore. I would have done what I could to stop the book's publication. The experts said the same. It's just not done. It's obvious. Joe said it too. Second reason here. Joe was trying to save the project from MacDonald, who would have tried to stop it. So, 1, stopping information flow. 2, saving the project. MacDonald would have done anything to stop the book's publication beforehand if he'd known the conclusions. Then there's another reason. Remember, we're dealing with a violent man, a man convicted of 3 murders. Joe feared harm to himself and his family. Remember, this fellow has a brother who is not well, who's been incarcerated for violent threats, who called Joe and his wife at home and talked about coming over. Joe and his family worried about just such violence. It's easy for counsel in closing to make light of such fear, but he jests at scars who never felt a wound. When the fear is real and when violence is around, you worry. Anyone who has felt fear and worry knows what I mean, especially if you have children. Now, the tapes. Much is made about whether there was some obligation by Joe regarding the tapes. First, let's be clear. The tapes were part of the cooperation. That cooperation was promised and agreed to. Access was agreed to. And MacDonald wanted to give those tapes. It was going to help the book, and as his counsel said yesterday, he was absolutely informed that they would be used in the book's overall context. He knew that. So how can he now say that's not true? They were used in the book's overall context, used very effectively and well. They were a substitute for interviews that couldn't happen because he was in prison. They were designed to help the book in which MacDonald himself had a financial interest. Another conflict. Whether there were little rappers saying they were confidential. The murderer said yes, he put rappers on. The author and his wife said no, there were never any such rappers. You decide who's telling the truth, who's making up a story after the fact. And add to that, when MacDonald wanted privacy on something, he'd write a note in a letter saying so. He wrote letters sometimes saying, treat such and such privately, I'm sending it to you, but I don't want it in the book. Think about that. When he wanted privacy, he wrote a note explaining it. Did you see anything in the letters where MacDonald says, don't use the tapes in the book? Did he say that? It was all the other way around. The tapes themselves show they were intended for the book. On one tape, he tells Joe, I like what you did in going to extremes. Using other people's words in the book makes it work. It's a good technique, and I know it will work. What could he be talking about if not using his own taped words in the book? Let's be real here. In fact, using the tapes is part of the book's fairness. It helps tell the story in MacDonald's own words. Not once in all the tape talk was there any suggestion they were distorted or inaccurate. Yes, of course, they were edited and spliced for coherence and clarity. Every expert said that's done, including Dr. Elliott a few days ago. He mentioned his Playboy interview, which had 1,200 pages cut to 156 with questions out of order, etc. That's how you do that. There's nothing wrong with it. Not to mention the second release, Exhibit 6, explicitly gave the author the right to do exactly that. So the tape issue is a phony issue. Now, we talked about a public relations campaign in August 1982, the phone call. What we really have to understand is this man's been on a public relations campaign since 1970. He was in touch with writers then. He went on the Dick Cavett show. He was contacting writers in 75 and 79, and 4 more writers now, all for publicity and celebrity. In fact, Dr. Stone said this trial, this litigation, is the same kind of craving for attention. That's how to see it. If there's been any fraud in this relationship, it's been MacDonald's fraud. The fraud on Fred Kassab that went on for 9 years, the fraud on everyone else. The only people he failed to defraud for a while were the criminal jury and the grand jury before that, the appellate courts, the Supreme Court that affirmed. He tried to defraud Joe, but he couldn't. And he spent 6 weeks trying to defraud you. You're not going to be the first judicial body to be defrauded. Counsel talked yesterday about credibility and lies. This murderer's credibility is worse than worthless. He can't be believed about anything. How do you determine who's telling the truth and who's lying? Use your common sense. Hear what they say. Test it against everything else you know. Watch how they answer. See their facial expressions. Nonverbal communication. Watch eye movement. See if they display phony emotional responses at wrong times and places, trying to simulate human feeling they don't understand. See how many other witnesses disagree with them and what those witnesses' motives are. If it's one person saying one thing and 5 people saying another, you wonder who's right. Look behind the words. We have a catalog of lies that could go on a long time. Let's pick the world-class lies, the super lies. The lies about killing one of the intruders he told Freddie and Mildred Kassab. Ridiculous, absurd, preposterous lies focusing on violence, which he's clearly preoccupied with. The lies about searching for the mythical intruders, concocting stories about a broken hand and how much it cost. These are admitted lies. He admitted those. And when the criminal jury convicted him, they not only convicted him of murder, they told everyone they thought he was a liar. Equally important here. When the appellate court described his trial story as a fabrication, they were saying he was a liar. The Baxter episode, absolute lie. You see the conflict in testimony, you judge it. To put it in perspective, recall when he was on the stand talking about what he told the grand jury. In 1974, before the grand jury, they asked, "Did you ever have a polygraph in April 1970? Remember, he'd had 2, John Reed and Cleve Baxter. His answer, no. That's what he told the grand jury. He lied to the grand jury. Then here in court, he says, well, the Baxter one I thought was incomplete, and I just forgot about the John Reed one. Now, how many polygraphs has he had in his life that he could forget one when asked by a grand jury? You can't believe that. He was trying to sell the grand jury the Brooklyn Bridge. The Wambaugh episode, he says Wambaugh offered him $200,000 or $300,000. Wambaugh says that's crazy, never happened. Pure fantasy. Who do you think is lying? Then the promise to Joe that he'd cooperate and give access to everybody. He didn't give access to Baxter, and you know why. Then we saw something in the courtroom. He said he spent 10 minutes with Dr. Silverman, psychiatric interview, and a lot of time with another doctor. Next day on cross, I confronted him with his memo asking, how much time did you really spend with Silverman? He said 2 hours, not 10 minutes, 2 hours, and you saw right in front of you, when confronted with a lie, he tried to say, well, that was during testing. But he was trying to mislead you. Every time he said on the stand, I don't recall. Remember how often that happened? I asked him things from transcripts, sworn testimony, simple questions. Every time it got a bit too close, too uncomfortable, he retreated to, I don't recall. Do you believe that? We showed it to him. He still didn't recall. How evasive does someone have to be on the stand? How many countless lies before he loses credibility? We could talk for hours about his deception within his marriage. We know what that was about. On the tapes, 2 of his comments reflect his attitude toward truth. 1, talking about a construction job he had one summer, he says, I was totally faking it. That's what he's done for 17 years. That's what he's done for 6 weeks. Then another comment on the tapes. It's a little hard to separate some of the facts from fancy. Those are his words. It might be hard for him, but it's not hard for us. We can separate fact from fancy. Most of what comes out of his mouth is fancy. Now, we heard talk about alleged false statements. We address them this way. Out of a 700-page book, look how much went unchallenged. The central theme that he murdered his family and is guilty was not challenged. And look at the challenges he did make. Remember, it's his burden to prove they were false, and you must separate fact from opinion. Also remember, once a subject is shown to be a liar, every expert testified the writer has no obligation to confront him with contrary versions, because it's the writer's job to make his own conclusions. Let's talk about the eschatrol amphetamine business. We don't have to show he actually took amphetamines that night and that caused the murder. All Joe says in the book is that it's possible. He notes it as a surmise and even says perhaps it's too much to surmise that. But Joe's treatment of that episode turns out, after this trial, to be perhaps far more accurate than anyone could have imagined. We have MacDonald's attitude toward amphetamines. On tape, he says, "I could understand taking some amphetamines. They weren't so bad, just to stay up and party a little." He talks about having taken them before. Denial is a hallmark of a drug abuser. If he admits to taking some before, imagine all he's not admitting, given his credibility. He's familiar with it from his brother's drug use. And on February 16th, 1970, we have his own handwritten note saying he may have taken it at supper time, when doctors' references say he's supposed to take them in the morning. He mentioned them in those notes prominently. He'd been tired for months, exhausted, moonlighting. He said on the stand he worked every night. Elsewhere, he said not every night. We caught him on that. He stays up till 2 a.m. that night reading, watching TV, washing dishes with surgical gloves at 2 a.m. Something he took that night gave him a second wind. Then look at his symptoms. Teeth chattering, chills, agitated, restless, irritable, insomnia. All match classic amphetamine psychosis symptoms. Some others quoted in the book, and MacDonald himself, say those are symptoms for other drug abuse patients he's seen. What do doctors and references say could happen? Delusions, hallucinations, psychosis linked to violence. Dr. Stansfield, the government's expert, specifically showed that in May 1970, a paper was delivered a few months after the murders linking amphetamine use with homicides in families and elsewhere. Speed is dangerous. Eschatrol was taken off the market because it was not proven safe. And eschatrol is more amphetamine than sedative. Now, delusions and hallucinations are very interesting because they lead to the conclusion that there were 4 intruders in the house that night in MacDonald's mind. The 4 intruders were intruding on his freedom, his independence. What he wanted was space. The intruders were Colette, Kimberly, Kristen, and the 4th was the unborn child Colette was carrying. Those are the 4 intruders, conjured by delusion in this man's mind. When Joe wrote that part of the book after speaking to Dr. Stansfield, he was actually proposing a sympathetic theory for MacDonald. He was saying a drug-induced psychosis, if it occurred, would have relieved MacDonald of some mental responsibility. Joe was really suggesting something favorable in a sense. Then you heard Mr. Barbato, the Army chemist. He unequivocally laid to rest any suggestion the Army had cleared MacDonald of having drugs in his system. He showed, as the chemist who did the test, that his equipment could not detect anything below a magnitude requiring MacDonald to have a vial of pills still in his mouth. It was orders of magnitude less sensitive than needed. So don't believe for a minute that the Army showed he didn't have amphetamines in his system, but all Joe has to show for the book is that it's plausible, reasonable. He doesn't have to prove it happened that way. Same with pathological narcissism. It would be a simple answer. Dr. Stone diagnosed him with pathological narcissism plus other personality disorders. Dr. Sadoff disagrees. But for Joe's opinions and conclusions, which were not quoted as statements of fact, merely allowing the reader to see a disorder's description alongside MacDonald's lifestyle for the reader to draw conclusions. There's no statement there. It's an artistic technique. But once an expert who specializes in that disorder identifies it as such, that's more than necessary to show that part of the book had a foundation. Remember when Bernie Siegel was on the stand as the first witness and counsel asked if he found anything false in the book? He said, just those two things, the eschatrol description and the pathological narcissism description. That's all he could find, MacDonald's own lawyer, in a 700-page book that he thought was false. And those are both opinions. The other alleged false statements are so easily rebutted and have been rebutted on the stand simply by the care Joe took in trying to find the facts, or rebutted by MacDonald's own admissions that the statements were untrue but that he was confused about when things happened. Otherwise, they're so trivial as to almost be an imposition on all our time to discuss them. And remember, as counsel said yesterday, this is supposedly not a lawsuit about the book, though he then says lots in the book they complain about. You can't have it both ways. Now I want to spend a moment on the three claims besides the contract claim and their elements: fraud, emotional distress, and breach of the covenant of good faith and fair dealing. On fraud, keep in mind, as the court will instruct, there must be a false representation of a fact. There was none here, hence no cause of action. On emotional distress, they have to prove, and it's their burden, that there was outrageous conduct beyond the bounds of decency that was not privileged. There was no outrageous conduct by Joe McGinniss. The outrageous conduct was on the other side of the table, and there was no severe emotional distress. On breach of covenant of good faith and fair dealing, the criteria for that claim simply aren't present. There wasn't a special relationship of trust or reliance between them. They weren't dealing in that capacity. And to the extent anyone breached the covenant of good faith and fair dealing, it was MacDonald. Keep that in mind when considering the causes of action. But most of all, this applies to all the causes of action. He suffered no damages. Where are the damages? How has he been harmed? How is a convicted triple murderer harmed by a book that says he's a convicted triple murderer? Is there any reputation left to harm? He says, well, it was the time he spent doing the tapes in prison. What else would he have been doing in prison if not the tapes? What other useful activity that would bring in money? What was his time worth in prison? Aside from the fact he already had the duty to do it, and that he did it out of his own financial interest and was not defrauded into it. He says he lost fan mail and some fan mail turned critical. Well, if letters from the public became critical because of facts they learned in fatal vision, then that's a good thing. People should be critical of triple murderers and maybe write letters. That's not a reason to sue the book's author. If he lost fundraising from people who might otherwise support his interminable efforts, that's not McGinnis's fault, and it may explain why he has to bring this lawsuit, to show his constituency he's still fighting. There are no damages to MacDonald. The only damages sustained are by McGinniss. Now, MacDonald has a claim for breach of contract, and we should talk about that. You've heard reference to the Dell payback. Joe switched publishers from Dell to Putnam. Under the agreement between MacDonald and Joe, Joe had the right to get the book published, negotiate, handle the financial deal. That wasn't MacDonald's end. MacDonald's end was to cooperate and supply life information, not finance. He'd just get his check and supply information. Joe and Sterling Lord arranged the finances. The original Dell contract was August 1979. In July 1982, Joe switched to Putnam. First, you heard Linda Healy say it's common enough to switch publishers, nothing special for writers. The reason Joe gave: the editors on his book at Dell had left. Dell was falling apart. Putnam was far superior. Also, the Putnam contract was a much better contract because the Dell contract included hardcover and softcover rights, while the Putnam contract had only hardcover rights. they could auction off the softcover rights separately to bring in more money. So it was a more attractive deal for everyone, including MacDonald. There's been talk about what it means when an author doesn't finish a book by a deadline. Testimony said it's very common. The completion date in a publishing contract is more a goad to the writer to move along than of the essence, particularly so for a book like this. John Gay talked about TV scripts. Someone asked how quickly he could write it. He said, "Do you want it today or do you want it good?" Joe wanted to make his book good, and he took the time, 4 years, to ferret out every piece of information and document it and do it right. Now, the Dell Termination Agreement, Exhibit 25, sets terms of termination. You should look at it in the jury room. Two critical things leap out for understanding this claim. Joe was required to pay back $280,000 plus interest, came to $298,000 under that termination agreement. Part of that money was to be paid back from the TV movie. There was a clause that 75% of the first proceeds of the TV movie would go to repay the Dell debt. This was a debt incurred on behalf of both parties to get the better deal from Putnam. Now, the documents, like with the creative freedom, spell out how MacDonald was told and knew it was his obligation as well. This notion he's now saying that he shouldn't have to share in the repayment is really silly. First, it's not common sense. Was he supposed to get 2 advances from 2 publishers, and Joe would pay back MacDonald's share of the first advance to Dell and be that much in debt? Remember Joe's difficult financial situation at that time. It's just not common sense. Both were going to pay it back in proportion to what they'd received, then get the new advance from the new company in the same way. That's how it works. There was no doubt about that. Exhibit 45 is a letter from Joe to MacDonald in which he talks about paperback rights reverting back to us. He says us. He talks about money going to us. He says the basic agreement between you and me is of course unaffected, meaning they still have their arrangement and it'll be offset with debits and credits. That's how people do this. Then he says, you might have to sell your mammoth condo next summer when Dell comes knocking on my door. That's a clear statement to MacDonald that the obligation is joint, and if it's not paid off in time via royalties and future proceeds, he'd have to contribute his share. There's another letter, July 13, 1982, from MacDonald to Joe. MacDonald says, "You're not paying it back alone, but from the future royalties to both of us." Exhibit 46, another letter in July 82. Joe writes back to MacDonald explaining more about the payback. This in no way affects our original contract, meaning MacDonald shares in the payback. In October 1982, Joe writes another letter to MacDonald and talks about Dell's legal right to recoup all monies paid out via advance, through me and us, from Putnam's to them, with another $143,000 due next July. None of that alters our original agreement. Later in that same letter, he says, I hope there's enough income to pay back Dell what is still owed them so we can get on the plus side of the ledger. Exhibit 230, another letter from Joe to MacDonald, December 82. Needless to say, none of this money will come to either of us immediately due to the payoff of advance and the Dell debt. Exhibit 9, letter from Joe to MacDonald, May 16, 83, explains more, giving details of sums coming in. Another exhibit, July 5, 83. Sterling Lord writes to MacDonald explaining the Dell payback again. MacDonald writes back July 9, 83 in his own handwriting, recognizing it. He says about the Book of the Month Club and New American Library deal, as Joe described these deals to me, both impact on the payback, thus impacting on future royalties to Joe myself. That's what the words mean. Everyone understood it was to be paid back. The interest, as testified, we have a total of $298,000, of which 75%, $223,500, was to be paid from the first movie dollars. Actually, 75% of $130,000 is $97,500. Correction, 75% of the $130,000 movie deal, not of the $298,000, is $97,500. There was some suggestion from counsel that it's unusual to have a two-book contract. When Joe switched from Dell to Putnam, he got a two-book contract. Testimony from Joe and Linda Healy said two-book contracts are standard and normal. It's a way for the publisher to lock in the author they want. They gave Joe a $50,000 advance for the second book. That was not a fabricated event. He has worked on that second book. But it wasn't to siphon money from MacDonald. It wasn't done to deprive him of anything. It was a separate transaction. Now the TV movie. Back to the original July '79 agreement, Exhibit 3. It says there's a split if it's a book, if it's a movie. 60-40. 40% to MacDonald, 60% to McGinniss. There are a cluster of rights involved. All MacDonald was giving or selling to McGinniss were the story rights plus cooperation, and it was the book rights. What he'd get with the TV movie, as the contract says, is the sale of the book to make a movie. That's the right involved. That's covered by Exhibit 14, the rights acquisition agreement. That was $130,000 from NBC. You heard that. That $130,000 falls under that part of the contract. But there were two other agreements that don't fall under the McGinniss-MacDonald deal: the script consulting agreement and the character acquisition agreement. You heard John Gay and Dan Wigatow say such script consulting agreements are common. Those aren't payments to the person who sold the book rights. Those are payments to someone else, maybe the author, maybe another consultant who helps with script writing. They are not part of the rights MacDonald can claim. They're simply different rights. John Gay talked about Joe's contribution in terms of voluminous notes, 19 pages of comments on the script, days working on the project, phone calls. Gay said Joe made more of a contribution than anyone he'd worked with, that it made a difference, that he wouldn't have done the movie without Joe's participation. That was not something MacDonald had any contractual right to share. That was Joe's work. He was an NBC employee for that. So that's out. Then we have what's been called Exhibit 16, the character acquisition agreement. The title doesn't tell half the story. That agreement goes far beyond buying the right to portray Joe's character in the movie. Perhaps more important is paragraph 1, which shows they were buying the right to ask Joe, and Joe's obligation to disclose all information he had. Newspapers, magazines, photos, transcripts, notes, other physical materials, Joe's thoughts, observations, recollections, opinions, reactions related to the story. That's the heart of what they were purchasing. Not simply to put an actor of him in the series. They needed that, quite apart from script consulting, to make that movie the hit it was, to make it good. That's what they were paying for. It's not simply a character acquisition. Paragraph 1, the very first paragraph, says that. They paid $20,000 for that. So MacDonald isn't entitled to anything from those two NBC contracts. The $130,000 is a different matter. Now, with respect to the $130,000, the Dell termination agreement, Exhibit 25, required 75% of the first movie rights money to go back to Dell. So of that $130,000, $97,500 goes to Dell. That's 75%. The remaining 25% is $32,500. You heard testimony that proceeds, as used in the basic contract, means proceeds to McGinniss. If he doesn't see the money, it's not proceeds. So that 75%, $97,500 straight to Dell was not proceeds. Only the $32,500 balance was available for distribution. We see part of the figures Mr. Bostwick put on the board yesterday, Exhibit 53, the Sterling Lord numbers. These are sums through August '84, when the lawsuit was filed, relevant to whether there was a breach then. and whether McGinniss owed MacDonald any money at that point. For the $130,000, we see the only amount of money available to distribute between the parties, instead of $130,000, is $32,500, because $97,500 went to Dell. On the NBC script and character agreements, instead of being those figures, they become zero, since MacDonald has no claim to them. Then if you take the $97,500 from the $298,000 owed back to Dell, you get $200,500 remaining owed to Dell. You have to deduct that from the Putnam royalties. That leaves $48,500, $249,000 minus $200,500. The rest of the numbers stay the same. If you total $375,437, sum totals from that exhibit, plus the unchanged numbers, you get the gross amount available as proceeds. That's the gross. Before distribution, certain things must be deducted, like commissions to Sterling Lord, Joe's agent. Sterling Lord's commission was, on the first $280,000 Dell advance, 10%. But with the switch, he only took half 5% of $280,000. That was $14,000. On the $200,000 Putnam advance, he took 10%, $20,000. At this point, the draft transcript cuts off the detailed arithmetic and transitions to Mr. Kornstein's conclusion, which I continue below. Mr. Kornstein concluding, a verdict for MacDonald would be a verdict for censorship. Make no mistake about it, it's a type of book burning. Once we start down that path, it's a path to darkness. We'd be going back to the dark ages where people were burned because they wrote things others didn't like. Lights would go out one by one until the only light left is from a bonfire of burning books. We don't want to start that. That's what this case is really about. Do you think for 1 minute if you return a verdict for MacDonald that other criminals in prison won't sue? That other non-criminals won't sue about books they didn't like? We don't want to go that way. That's not what we're about. You must return a verdict in favor of Joe McGinniss and against this convicted murderer. You mustn't give this fellow more money for killing his family. You have to send a loud, clear message to people like him that they shouldn't bring suits like this anymore. But perhaps more important, send it to writers and readers so they know freedom of expression is safe and you're protecting it. Now, the releases are one of the keys here. Both releases were designed to protect that freedom, to allow the writer to write, and they were freely entered into. One of the great things about contracts is they're an aspect of freedom. Freedom of contract. You sign something, you're free to do it. And in doing so, you give up part of your freedom. That's what a contract is. It's a noble and good concept. A contract's a contract. A deal's a deal. That's what we're talking about. And specifically, we ask you return a verdict against MacDonald on every one of his claims. The releases are an easy way to do that, though every other aspect works as well. But the releases handle it right at the start. On our counterclaims, we ask you return a verdict of at least $190,000, but you should determine the appropriate amount. There's no better way to conclude than Bill Buckley's comment that Joe McGinniss has a ferocious honesty set against the final comment in the prosecutor's summation at the criminal trial. It's in the book. What Jim Blackburn said to that jury applies equally here. Ladies and gentlemen, if in the future, after this case is over, you should think of it again, I ask you to think and remember Colette, Kimberly, and Kristen. We asked for nothing in the name of persecution. We asked for nothing in the name of harassment. We asked for nothing in the name of what is wrong. Nothing. But God, we ask for everything in the name of what is right and in the name of what is just. That is why we are here. We ask for everything in the name of truth. Thank you.